So, today I want to talk about the precedent of Roe v. Wade being overturned and which laws will be targeted next. So, in the last video, I talked about Roe v. Wade from an anarcho feminist perspective and criticized its liberal justification as violating bodily autonomy. Today, I want to bookend this series by discussing what laws will be targeted next now that Roe v. Wade has been officially overturned. That said, before we continue, I would like to note that I outlined these ideas before the decision to overturn Roe was made official. All of the ideas presented here were extrapolated based on the tactics of conservatives and the justifications made in the Roe v. Wade case. Because of this, I have left my outline more or less intact in order to demonstrate how we can extrapolate this information from the information that came prior. That said, Justice Clarence Thomas has confirmed in his opinion that some of these ideas are indeed where the court is likely to go next, and we very much need to listen to that. What he states in his opinion on Dobbs is, quote, "For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell." And these are the three that are easily predicted and extrapolated if you look at prior tactics. Now, we have to take it very seriously, especially now that they're saying this part out loud. But they weren't really saying this part out loud. There were usually only test balloons putting out the ideas. And beyond that, we really didn't have concrete information. So I think that's why it's most important to look at the fact that we can extrapolate this information based on what has come before. So with that said, getting back to extrapolating that prior information, now that we understand the full context of the conservatives' purposeful agenda, it should be apparent that overturning Roe v. Wade and stopping legal abortion was unlikely to ever be where they stopped. Given that, and that we have a greater understanding of the liberal justifications for Roe v. Wade, we should be able to make educated guesses as to which rights will be likely targeted next by the Supreme Court and by conservatives. So given that Roe v. Wade was justified via the 14th Amendment, and that the presumed right to privacy was the primary reason that was cited in the Roe case, as well as the information that the justification for striking down Roe was that certain forms of privacy are not based in the United States' history and tradition, it's reasonable to assume that some of the first laws to be challenged would be those tied to this very same right to privacy that conservatives have been trying to target for a while. This would include things like contraception, gay marriage, and intimacy between same-sex individuals. All three of these are tied to the exact same privacy and liberty understanding represented in the 14th Amendment. As a matter of fact, Griswold v. Connecticut, which protects contraception use, was used as part of the justification for privacy under the Roe v. Wade decision. And recently, we've also seen a number of state legislatures start to talk about potentially banning contraception as the logical next step after Roe. As a matter of fact, we find that in Arizona, the Tucson-based venture capitalist Blake Masters has actually boasted that if he is in fact elected, that he will only vote to confirm federal judges who understand that Roe and Griswold and Casey are wrongly decided, and that there is no constitutional right to abortion. Roe v. Wade and Planned Parenthood, of course, are tied to the constitutional right to abortion access, but the ruling in Griswold in 1965 protected a married couple's right to buy and use contraceptives without government restrictions. Additionally, we see that in Missouri, conservative Republicans in Missouri legislature took a run at blocking Medicaid funding from going to Planned Parenthood, as they typically do. But in the fine print of their measure, those Republicans revealed that their ambition wasn't only to target a familiar abortion foe, but they were going to attack specific forms of birth control as well, notably emergency contraceptives, often sold under the brand name Plan B, as well as IUDs. GOP lawmakers tried to stop Missouri's Medicaid agency from paying for those forms of contraception. Missouri State Senator Paul Wieland, one of the Republicans who led the effort, explained his position this way. The bottom line is that there's only one time something definitively happens, and that's the moment of conception. Once that happens, anything that happens should not be state funded. And the level of disconnect that he has here in terms of actually understanding how things work is beyond the scope of this. But this is not how any of this works. These are not abortion pills. These are contraceptives. These are ways to prevent the pregnancy from happening in the first place. And they are even targeting that. Now, if I've learned anything about the conservative strategy over the years, it's that when they start making moves like this, when they start talking about things, they will try to act on it in the near future. The unfortunate reality is that this move seems very likely from the anti-abortion crowd, whether their goal is to control sexuality or they do genuinely believe the pseudoscience that they tend to purport. A good number of them probably see contraception as an evil that prevents the natural order of pregnancy, something that should happen uninhibited. I think even still, others probably see it as a form of abortion, which is completely medically inaccurate. Now, next in line is probably gay marriage. Gay marriage has only been protected by the Supreme Court's flimsy privacy argument for about 7 years or so. That said, Obergefell versus Hodges barely tipped in the favor of gay marriage. Now that there are 3 Trump-era appointees in the courts, it's hard not to imagine the court overturning this decision. In addition to this, it's worth noting that Republicans don't even have to set up their state legislatures to handle this, like the ones we saw that are trying to create exceptions for contraception. In fact, what we see is that they have rulings already on the books from before it was legalized. Before the Supreme Court struck down bans and legalized same-sex marriage, 31 states had enacted laws banning same-sex couples from marrying. The laws have not been in effect since the courts ruled them unconstitutional, but they remain on the books in most of those states. So, states will actually have their rulings in laws to ban gay marriage already in effect. And if the Supreme Court were to overturn this one case, these states will be in a place where they will already have all of these marriages illegal. What will this mean? Well, it means either they annul the marriages, or at the very least, they no longer recognize currently married people, and definitely will not allow for more marriages to take place in their state borders. Now, what that will mean for recognizing marriages from outside of state, who knows, but based on the history that we've seen, it will probably be extremely unlikely that they'll recognize any marriages from out of state. So the last of these 3 major privacy laws that I see falling is actually the decriminalization of sodomy under Lawrence versus Texas. Now, while many don't realize this, 16 states, that's right, 16 states, still have anti-sodomy laws already codified into law, which again may kick right back in if the Supreme Court overturns a single decision. Now we have here, as of 2020, there are actually 16 US states that still have sodomy laws against, quote, perverted sexual practice and, quote, crimes against nature. According to the ACLU, laws against sodomy were originally designed to prohibit any sex that was not for procreation, and so included crimes like having sex outside of marriage and bestiality. When we look at where this is actually illegal, sodomy is illegal in Alabama, Florida, Georgia, Idaho, Louisiana, Maryland, Massachusetts, Michigan, Minnesota, Mississippi, North Carolina, Oklahoma, and South Carolina. 3 states specifically target their statutes at same-sex relations only: Kansas, Kentucky, and Texas. Now, while there are those 3 states, I also feel the need to emphasize that sodomy historically represents a lot of different sexual acts. While most people typically think about it as gay sex or intimacy between same-sex individuals, sodomy laws also extend to many heterosexual acts, including certain forms of sex between married couples. It'll remain to be seen how far the court is willing to actually go in terms of these laws. And to be honest, I can say that given the language I've seen from a lot of conservatives, they still think that things like sex outside of marriage is degenerate no matter who it's between. So I would not be surprised if they strike at people's sexual autonomy in the strictest way possible and attack any form of sex that isn't for procreation. Now, given that privacy is the justification for Roe as well in these other cases, I do want to reiterate to everyone something that I mentioned in the first part of this video series on Roe, and it's an extremely important point. Our data may be used against us since privacy itself may come under attack if the law is interpreted a certain way. A lot of places have talked about the implications of privacy under Roe. And I want to look at wired.com where they say, quote, if you know that you're doing something that's risky, just be cautious about how you talk about it on the internet. Or don't talk about it on the internet at all, says Kat Green, managing director of Abortion Access Front. And if you can avoid being explicit about what you're asking for and what you're talking about, it's better not to text somebody unprotected on SMS and be like, how do I get abortion pills? Across the board, abortion access proponents recommend talking about anything that might carry risk on an end-to-end encrypted message app like Signal, with the disappearing auto-deleting feature turned on so your messages don't hang around on your device or the device of the person that you're talking to. Apps like Signal also offer end-to-end encrypted calling and even video chat to keep snoops off your call, and your call and text logs off your phone's company records. And this is really important because if the police ever take out a warrant against you, they can get access to your data and they might know what you're doing. And I want to reiterate that our data may be used to attack us and enforce these laws in ways that they never could have been enforced historically. All that's required is a warrant, and any message you send talking about sex, abortion, being LGBTQ, or anything else may be something that can be used against us as our privacy is erased. While I don't know how quickly such a thing could be implemented and how all of the data could be managed and searched, what I do know is that those who stand up the loudest and those who are in the most vulnerable populations will probably be the ones who have their data targeted first. In addition to all of those, I believe the courts will also protect any state laws that have imposed voter ID restrictions, anti-trans bills and legislation, and further dismantle unions and labor movements. I believe they will even target the Civil Rights Act as unconstitutional under the twisted logic that it discriminates rather than protects. The fact is that anything that you've seen come out of the states, anything that has been ranted and just pushed by conservative pundits, they will uphold it all. It also needs to be said that if the courts can't do it, then the Republicans will do it whenever they get federal power back. They will implement every policy and steamroll the Democrats. They'll remove the filibuster, they will pass legislation, codifying all of the state laws into federal laws. And yes, that includes a federal ban on abortion. And the Supreme Court will completely ignore it and allow it to happen. The originalists have made their goals quite explicit. And when someone tells you who they are, just like Justice Clarence Thomas has, it's best to listen. They want to see the end of civil rights, the end of the New Deal protections, and they really want to see us go back to 1910 where abortions were illegal and white supremacy and eugenics were standard protocol, and if we let them, this is where they're going. This is their dream world. This is conservatism, and this is fascism. With that said, if you've enjoyed what you watched in this entire video series, consider liking the videos and going back to watch any that you might have missed. Consider subscribing and leaving a comment, as well as joining my Discord. If you're in a financial place to do so, and only if you're in a financial place to do so, please also consider supporting me on Patreon, especially as this political content like this can become demonetized on YouTube very easily. The links for everything that I mentioned are in the description down below. With that said, thank you for watching this entire series. My name is Anarchist Tara. I hope you have a lovely day.